Right now, at this very moment, immigration lawyers across the United States are filing urgent reports, sending emergency alerts to their clients, and raising alarms that every immigrant, every visa holder, every green card applicant, and every naturalization petitioner in this country needs to hear immediately. USCIS, the United States Citizenship and Immigration Services, has effectively placed an adjudication hold on cases across the board, not on a category, not on a region, across the board. And the reason given is a sweeping new vetting process that has been quietly implemented at the federal level. If you have a case pending with USCIS right now, or if someone you love does, what I am about to tell you in the next few minutes could be the most important immigration update you hear all year. Do not go anywhere. Welcome to Global Entry News, the channel dedicated to bringing you accurate, timely, and clearly explained immigration news from across the United States and around the world. If you are new here, please subscribe right now because this is exactly what we do. We cut through the confusion, the political noise, and the bureaucratic language to give you the real picture of what is happening with immigration policy and how it affects real people. For everyone who has been part of our community, thank you for being here. Let's get into this, because it is serious and it is developing fast. Immigration attorneys from coast to coast, practitioners who work daily inside the USCIS system, who file petitions and track case progress for a living, are now reporting something they have rarely, if ever, seen at this scale. Cases that were actively moving through the adjudication pipeline, cases that were days or weeks away from a decision, cases that had already been through multiple rounds of review, they are now sitting frozen. Requests for evidence are going unanswered. Interview scheduling has stalled. Approval notices that were expected are not being issued. And when lawyers call USCIS to find out what is happening, they are being told that a new enhanced vetting protocol is in effect and that cases are on hold pending review under this new process. Let that sink in for a moment. This is not a backlog in the traditional sense. A backlog means the system is slow. What lawyers are describing right now is something categorically different. It is a deliberate pause, a policy-driven hold, and the distinction matters enormously for the millions of people whose lives, livelihoods, work authorization, family reunification plans, and legal status in this country depend on USCIS moving their cases forward. So, what exactly is this new vetting process, and where did it come from? Based on what attorneys are reporting and what has been pieced together from internal agency communications and policy memos that have begun to surface, the new vetting protocol represents a significant expansion of the background check and national security review process that USCIS conducts on immigration applicants. Previously, background checks and security screenings were conducted as part of the standard adjudication process. They happened alongside case review, not instead of it. What appears to have changed is that USCIS has now implemented a requirement for additional layers of vetting to be completed before any adjudicatory action can be taken on a wide range of case types. The case types being reported as affected span an alarming breadth of the immigration system. Employment-based petitions, including H-1B, L-1, O-1, and EB categories, are reportedly impacted. Family-based petitions, including I-130 spousal and parent petitions, are in the freeze. Asylum-related applications, adjustment of status cases, naturalization applications, and even DACA renewals have been flagged by attorneys as experiencing unusual and unexplained delays consistent with what is being described as a systemic hold. In short, there is virtually no corner of the USCIS caseload that appears to be exempt from what is happening right now. The timing of this is not accidental, and understanding the broader context is essential to understanding why this is happening and what it means going forward. The current administration has made immigration enforcement and vetting reform a centerpiece of its policy agenda. Executive orders have been signed directing federal agencies to implement more rigorous screening of immigration applicants. The definition of who qualifies as a national security risk for vetting purposes has been broadened. And agencies like USCIS, which historically operated with a degree of institutional independence, focused on processing legitimate applications efficiently, are now being directed to apply a far more restrictive and expansive security lens to every case that comes across the adjudicator's desk. What makes this particularly complicated from a legal standpoint is that USCIS is not required to publicly announce a policy hold of this nature. The agency can implement internal procedural changes without issuing a public notice in the Federal Register, without holding a comment period, and without giving applicants or their attorneys advance warning. The only way these holds become visible is when practitioners who work inside the system every day start comparing notes, which is exactly what is happening right now, as immigration lawyers across different firms, different states, and different practice areas are all reporting the same pattern. The human cost of this hold is staggering when you think through the real-world implications. Consider the H-1B visa holder whose work authorization expires in 60 days and whose extension petition is now frozen. If that extension is not approved in time, they lose their legal work status, potentially their job, and face the prospect of having to leave the country. Consider the family that has waited years, sometimes a decade or more, for a family-based immigrant visa to finally reach the approval stage, only to now be told that their case is on hold under a new process with no timeline given for resolution. Consider the asylum seeker who fled violence and persecution and has been living in legal limbo, waiting for their case to be adjudicated, now facing an indefinite extension of that uncertainty. These are not abstractions. These are the real consequences of what is being reported. From a legal challenge standpoint, the options are limited, but they exist. Immigration attorneys are exploring mandamus lawsuits, federal court actions that can compel an agency to act on an unreasonably delayed case, as one potential avenue to force movement on frozen files. Some attorneys are filing emergency motions and seeking status updates through formal legal channels. But the challenge is significant because if the agency's position is that the hold is a legitimate exercise of its national security vetting authority, courts have historically been reluctant to second-guess executive branch decisions in the national security space. Congressional offices are beginning to receive an elevated volume of constituent case inquiries related to USCIS delays, and some members of Congress who sit on judiciary and immigration committees are reportedly seeking briefings from USCIS officials. Whether that oversight pressure translates into any meaningful action or transparency from the agency remains to be seen. So, what should you actually do if you have a pending USCIS case right now? The first thing to do is contact your immigration attorney immediately if you have one. Do not wait for your attorney to reach out to you. Call them today. Ask them specifically whether your case type is among those being reported as affected by the hold. Ask them what your current case timeline looks like, and ask them whether any action needs to be taken on your end to protect your status or work authorization while the hold is in effect. If you do not have an immigration attorney and you have a pending USCIS case, now is the time to get one. This is not a situation where navigating the system on your own is advisable. The complexity of what is happening right now and the potential consequences of mishandling a response to it make qualified legal representation more important than it has been in years. Third, check your case status regularly through the USCIS online portal. If your case was showing active movement and has suddenly gone quiet, document that. Note the date when movement stopped, save screenshots of your case status page, and keep records of any communications you receive from USCIS. That documentation will matter if your attorney needs to file a mandamus action or any other form of legal challenge. Fourth, if your work authorization, your visa status, or any other aspect of your legal presence in the United States has a time-sensitive expiration date, flag that immediately with your attorney. Cases involving imminent status expiration may qualify for emergency or expedited processing requests, even within the current hold environment. USCIS does have an expedite criteria framework, and while approvals of expedite requests are not guaranteed, they are possible under the right circumstances. Fifth, be cautious about the information you consume and share about this situation. Because this is a developing story with significant public interest, there is already a lot of misinformation circulating on social media about what the hold means, who it affects, and what people should do. Rely on attorneys who are actively practicing immigration law, on credible journalism, and on channels like this one that verify before they report. At Global Entry News, we are going to continue following this story as it develops. We will bring you updates as more information becomes available from attorneys, from legal advocacy organizations, from congressional sources, and from USCIS itself. The situation is fluid, the implications are enormous, and you deserve to have the most accurate and current information possible as this unfolds. If this video gave you clarity, gave you a next step, or gave you information that you needed to hear, please take a moment to like it and share it with a friend who has a pending case, with a family member navigating the immigration system, with anyone who needs to know what is happening right now. Sharing this video is one of the most direct ways you can help someone who might otherwise not find out about this hold until it is too late. And if you are not yet subscribed to Global Entry News, please subscribe right now and turn on your notifications so you never miss a critical update like this one. The immigration system touches the lives of millions of people who came to this country with hope, who followed the rules, who filed their paperwork, paid their fees, and waited their turn. They deserve transparency, they deserve accountability, and they deserve to know the truth about what is happening to their cases. That is what we are here for, every single day. Until next time, stay informed, know your rights, and keep watching Global Entry News. We will see you in the next one.